Welcome back to BCB Live, the safest station in the nation. We're joined today with Dana Moore and Peyton Inge. And folks, here we go. How do you say Pete? Is it Buttigieg? Is it Buttigieg? Anybody know that?
I thought it was
Absolutely.
Buttigieg.
I don't know if it is or not. Anyway, it's just Pete. Here we go. U.S. Secretary. Hey, welcome to BCB Live. We're excited to have you on here. I know Buckle Up Bob, worked hard to get this kind of set up. And Bob, you know what? Let's start this here. How about Dana and Peyton? Can you tell us just a little bit about who you are, what you represent, and I guess that's probably good right there.
Yeah, just start.
Well, I'm Dana Moore, and I'm with the Texas Trucking Association. I'm a retired Texas DPS, where I taught commercial vehicle classes to the DOT officers for 16, 17 years. And now I represent TXTA as a government relations director. And I also do some training for drivers as well as carriers.
All right.
I'm
And
Peyton
been a
Inge,
guest with us
commercial
before.
officer, trucking companies around the country. Paid for school driving a rock bucket. Started off driving a cattle truck for my grandfather out on the ranch when I was young. Trucking's basically been a part of my life despite the fact I went to law school.
All right. And Peyton, from what I understand, you got yourself a Peterbilt, and you do a little racing with it. Is that right?
Well, not racing with the truck, but I sure drive it around the country. She's an old 82 feet 359, and drive that thing absolutely everywhere.
All right. And we've been talking last week, and this is kind of where we get going here. We've been talking about the do's and the don'ts when it comes to accidents, right? At the accident scene, buckle up, Bob. What do you have any comments on that?
Yeah, some of the things, when during our research is the burden of proof, Peyton, and I came across a term that I didn't understand, and maybe you could address it. What is comparative fault as a defense? I've never heard that before. I didn't know if you did. And then maybe, we can focus on the liability issues, that how we can help protect the drivers and the companies, what they need to do to help protect themselves in liability issues.
Absolutely. Yeah, the concept of comparative fault simply means that we're going to point the finger at typically the offending driver, the adverse driver, and we're going to say that driver is the one that actually caused the wreck. And I think in the cases I see, the cases we take to trial, it's probably 80% the fault of the other driver in 80% of the wrecks we see. And that's one of the things that we really work on with the jury. If we have to try this case, it's what the other driver could have done to avoid running into our truck.
Do pictures, we talked a lot about pictures, do's and don'ts last week. Do they come into play in that comparative fault at all?
They sure can. And that's one of the things that a driver can do at the scene that really helps if we have to go try this case, is taking pictures of where the vehicles came to rest, of the road, signage. All of that is incredibly useful for helping me prove that our driver, his account is the accurate account. And then when we're talking about photographs of the damage, a lot of the cases we see, they're extremely minor incidents. But being able to point to a photograph of, a 20-mile-an-hour bumper that's barely scratched is very, very useful for being able to put the plaintiff's story in context.
Gotcha. And Dana, when we think about Texas, things have changed, right, over this year, say, compared to 2 years ago. Talk to us a little bit about litigation inside of Texas now and some of the changes said the TXTA has been behind in getting done.
Was that question for me? I'm sorry.
There you go. That was for you there, Dana. Sorry about that.
I'm gonna defer that back to Peyton since he tries these cases.
And I'm having a hard time hearing you as well. Would you mind asking that one more time?
No, you're good. So regarding some of the say the reform that we here in Texas have gone through, right? Changes. It has any of the new policies. What has that done to you on the litigation side? How about that? Regarding policies today versus say 3 years ago. HB 19, for example. What has that done for you in trying cases or protecting the carrier?
Well, okay, so the law is very, very new. The biggest impact it's had for me is being able to tell judges that sometimes are a little bit enamored with these plaintiffs' attorneys that spend a lot of money on their election bills, is saying, hey, judge, this bill was required because this type of plaintiff's lawyer was making this exact same type of argument, in that they're entitled to get thousands of pages of records, and they're able to talk about negligent entrustment, hiring, and all this other jazz. And I say, Judge, look, it was so bad that the Texas legislature had to step in. And look, these are all the types of arguments that are now prohibited making at this stage of the trial. And what I found is that the judges have been very receptive to that, because they do understand that a lot of what the plaintiffs are asking for is simply absurd from a legal standard. And, the Senate bill has been very, very useful from that standpoint. Looking forward and down the road, I think it's going to be incredibly useful for limiting a lot of the more extraneous type arguments I hear in the early stages of litigation about discovery and things like that. And I also like the ability to bifurcate the trial if we have to go try it.
And I sit there and I hear you talking about educating the judges out on the bill. I'm just curious, Dana, I was going to ask you as well, how important is it that we educate not only the drivers, but the trucking companies and all this, and how do we go about doing this effectively for going forward with this type of litigation?
The bill has a number of things that every driver and every carrier should be doing. Now, if you're interested in seeing this list, we developed it. It's on our website, texastrucking.com, and just go to the advocacy tab, click on it, and you can download a PDF version. I mentioned a while ago the bifurcation trial, and I'll let him explain a little bit more about that, as he is the lawyer on this program. But there is something called negligent entrustment, and when they bifurcate or separate the trial into two phases, the first phase is all about the negligence of the driver, or alleged negligence, and the alleged negligence of the carrier. And what can be brought in, essentially the facts relating to those, not all the other things that they've been bringing in that have nothing to do with the crash. Of the things that every good carrier should be doing and every professional driver should be doing. I'll kind of summarize them. When asked about this, I said, well, pretty obvious that a driver should be properly licensed and not in violation of any restrictions and in compliance with any endorsements that are required. That's pretty simple right there. The fact that the driver is not disqualified from standard drug and alcohol testing or whatever. The license is clear and valid. The driver's taken a road test if one is required. Now, that's another issue, but road test is not required in every single case, but if one is required, then one has to have been done. Another one that drivers can really easily work on or be in compliance with, is medically certified. And that means not only getting your medical certificate, but also making sure that your licensed state, they call it State Driver's License Agency, in this case in Texas is Texas DPS, has that on file. Because as you know, if it's not on file, after 60 days, the license is downgraded to a Class C driver's license. Not operating the vehicle while prohibited from any kind of drug and alcohol testing. And this is a huge one right here. Not operating a handheld mobile phone or texting at the time of the crash. Now, I think most all companies have a policy on that now, and besides that, it's law. And to think about it, maybe Peyton wants to talk about that a little bit more in his experience. But if you think these attorneys cannot figure out whether or not you were on your phone, you may be mistaken, or you were not texting. And if you ever, as a driver, refuse or fail the drug test, cannot perform any safety-sensitive functions, which includes driving, and of course, not subject to the any kind of out-of-service order. So if you were to, by chance, get put out of service roadside, say for hours of service or something, and then you drive off violating that out-of-service order, Now, this opens the door for negligent entrustment in the first phase of the trial. And the last thing I'll say about this is carriers have a dual responsibility in this area because they have to make sure the driver is doing these types of things, with the exception of carriers need to make sure that the driver actually has an application on file. And that's part of the hiring process now, it has been for a number of years. Just double check the records and make sure there's an application in the file.
Hey, I want to kind of mention one of the things you had brought up, and that's that cell phone policy. Peyton, I'm going to throw it over to you. The cell phone policy, I know most companies, if not every company, has a policy. Is that enough in litigation, or do these companies, especially say a company-owned fleet, do they have to, should they use other technology, say that the ping or the no-cell, that technology that does disable those phones while that company driver is say, driving that truck?
So many of the folks I run into, they know that it is incredibly important to make sure they're not on that phone while they're driving and they're not texting. But I do run into cases all the time, and I've got a fatality right now where my driver didn't do anything wrong except that he was texting, and it's obvious on the camera. I think, the prudent companies these days are simply reminding folks you cannot be texting on that phone while you're driving. I think that's the best way to proceed.
Got you.
Hey, I was going to ask him, we talk about that, and we talk about not being on the phone. Does that incorporate or also include hands-free? I mean, if you're talking hands-free, which is allowed by law, but you see that as a problem area as well? Because, we have two different views on that, and if you're using it hands-free, are you on the phone or you shouldn't be on the phone? How do you view that?
So I am personally okay with the driver that's on the phone using a hands-free device in most cases, as long as they're able to comfortably manage traffic. It is obviously something that comes up all the time when we're talking about, should the driver have been on the phone or not if we have to go try that case. But at the end of the day, jurors are just fine with it in most cases, as long as you're using that hands-free device, because it's not excluded. It's the texting that really I have a problem with because it does distract the driver for such a long period of time. It's really quite hard to explain.
Yeah, for sure. Speaking to that, some of the communication we've had here, what is your viewpoint again? And for those companies that don't run the forward-facing camera, the outward-facing camera, is that just something we all have to have?
So you live or die by the camera footage that you get. But I will tell you that 9 times out of 10, the camera footage that I find is incredibly useful to defending that case. And I strongly encourage companies, individual drivers, if you think you're a good driver, you trust your drivers, even an inexpensive forward-facing camera can save you a lot of money if something unfortunate happens.
Okay, now I got to ask this one here because I question my follow-up question is, what about the driver-facing camera? Is that looked a little different than the forward-facing or the outward-facing camera?
Yeah, there are a number of trains of thought on that, but I'll tell you, in my experience, there's only been 1 or 2 instances where an inward-facing camera showed me something that was useful. And what I find more often than not is if you have an inward-facing camera, even though the driver's not doing anything wrong, it does. It's something that the plaintiff's attorney picks on. Why did the driver see X, Y, or Z danger up in front of them when the driver didn't do anything wrong to begin with? And so I really personally don't care for the inward-facing cameras in most instances.
Well, I appreciate that. Y'all have anything else? I know we're running. We got about a minute and a half. Hey, Dana, what are you working on today with the TXTA? Anything that we can get behind you and help you with?
Absolutely. The entry-level driver training, that goes into effect on February the 7th. We've been reminding our members for some months now to make sure that they are aware of this. One of the questions, or probably the number one question that I'm getting, and I've confirmed this with Texas DPS and also at a conference I was at last week with FMCSA. What about if I have started, I've got my CLP, I've taken my test, and but I haven't gotten my road test and gotten my CDL by February the 7th. And essentially, once a driver starts the process before February the 7th, then they stay under those rules. Now, if you wait till February the 7th and go down there and do your application, you're under the new ELDT rules.
Gotcha. Drive safe.
Wow, that's interesting. And do you have any other litigation you got coming out, Dana, that we were talking about that you guys are working on, like where Rick was talking about in regards to, I guess what I would like to know is like education for everybody, the drivers out there, the companies out there. What are y'all working on to help better them on your webpage?
Well, like I said, we have this information that I talked about earlier in the form they can download. Really, right now, as far as litigation, I think Peyton will probably agree with this. We're kind of just watching to see what the trial lawyers are going to do. They're going to be looking for ways around this. And so TXTA and our associate attorneys like Peyton, we're watching it, and they're kind of keeping tabs on what's going on in the courtroom.
Gotcha. Hey, folks, I want to tell you, we appreciate you. And listen, everybody, the listeners out there, this is a battle. We've got to make sure we're doing what we can do to help these folks, help us out. We've got to make sure, and Drive Safe Dave, as we talk. And Dana, I want to tell you all, thank you, Dana Peyton. Thank you for joining us today. Very nice to have you here because let's face it, we see the commercials, right? These plaintiff attorneys, they're getting on jets. That tells me they're making a lot of money. They have their own jet, like in their backyard, and they're getting on it, saying, you know what, if you've been hit by a car or by a truck, give us a call. And it's not just the Hammer, it's a lot of these folks now.
It's out there. It's on billboards. It's on the television. It's everywhere you turn. It's on the papers, magazines. And then everyone knows I was bumped. All of a sudden, yes. I got a neck problem. I mean, I'm just saying, we all understand what goes on here. We've just got to be genuinely prepared.
Hey, listen, we're going to go to a break. Again, want to encourage you to be part of the TXTA. I want you to work on some of these practices that Buckle Up Bob's been talking about, because it helps folks, like Peyton, to protect us in our industry. Make sure you're doing the right thing. Make sure that you're getting those pictures. You're getting, if you have that forward-facing camera, that outward-facing camera that's being used, and don't text and drive. You heard it right there. Don't text and drive. Baby steps, right? If there's things that we can work on, don't watch Netflix on your TV, don't do drugs, and don't text on drive. Those are things we just can't do. Listen, we're going to be back to you in about 30 seconds with BCB Live, the safest station in the nation.